I have communicated several times in the last few days, so I can go quickly as to the motion in limine regarding penalty phase, regarding a lingering doubt. I have no objection to that.
Okay,
I know I cannot argue that. However, I did want to point out that certainly that does not mean that I cannot tell the jury that despite all the weighing of aggravating and mitigating circumstances, they ultimately can vote to what they believe is the correct thing to do. But
And we're talking about, just for the record, so it's clear, the state's first penalty phase motion for order in limine, right?
Yes, ma'am.
Okay, I just want to make sure, because there were a number of states' motions, so. Correct. That doesn't impede your right to argue the balancing of aggravating and mitigating evidence. Just means no one can get it. Once, if the jury finds the defendants guilty of capital murder, then during the penalty phase, the parties may not relitigate that.
I agree.
Okay. All right. So I will, as to Mr. Rashad Murphy, that motion will be granted. Okay?
As to the state's second penalty motion, we do not object. I would not get into anything dealing with the details of the actual method of execution.
Okay. So as to Rashad Murphy, that's granted. State's third penalty phase motion.
The third one, Your Honor, the same, with no objection. I would not be getting into religious beliefs.
Okay. All right. As to Rashad Murphy, grant the state's third penalty phase motion for order in limine.
As to number 4, and tell me if I'm going too fast.
No.
A description of death on television shows, etc. No objection to that.
Okay. As to Rashad Murphy, be granted.
As to number the fifth motion, I would not intend to, and this is something that I know the state's going to object because Mr. Harmon already told me he would, but I would not plan to get into details of other types of cases, such as mentioned Charles Manson, Ted Bundy, etc. However, when the state files a motion seeking, or a notice seeking the death penalty, they are in effect telling the jury that they believe that this case qualifies as the worst of the worst because it deserves the death penalty. And I think that opens the door for me to be able to argue that this is not the worst of the worst if in fact we were in that situation. And I should be able to talk about comparing it to other capital cases to the extent that the death penalty, this case does not mean worst of the worst. I should be able to talk about torture and serial killing and things of that nature because I would need to separate the facts of this case from other cases that I would argue would be the worst of the worst.
So are you talking about just making a general argument at penalty phase as opposed to saying things like, this is not Granville Ritchie, where a 9-year-old girl was raped and murdered. This is not Angel Kuzchok, where a 4-year-old girl was stabbed to death. Is that what you're talking about?
Yes, ma'am. I wouldn't be even mentioning other names, but I think that if the facts of this case do not have torture, if the facts of this case do not say serial killing, I should be able to make those distinctions.
Sure, just generally speaking, that this is not the worst of the worst that would warrant a sentence of death, right?
Yes, ma'am.
Any objection to that, just that general argument at penalty phase, assuming we get there?
Judge, I do object to that. And if you look at the state's motion, and I cite the Lockett v. Ohio, Lockett holds that not only the sentences in other cases, but the circumstances of other cases, which would include torture or serial killers. There are many types of serial killers. There are many types of circumstances. There was a Timothy McVeigh bombing in Oklahoma that killed over 100 people. There was Hal Donaldson, who recently killed 4 people here in Seminole Heights in Tampa. Ted Bundy. Oscar Ray Bolin, who was responsible for 3 young women here in the Tampa Bay area. They're all different. They're all distinct. All the defendants were of different ages. They have different circumstances. To simply say this isn't torturous or this isn't a serial killer, it's even worse because you're leaving it up to the imagination of the jurors. And that's not what they're supposed to be doing. They're supposed to be assessing and conducting an individualized sentencing proceeding for this defendant to give him his due process rights. They're not supposed to be speculating about other cases and the relative proportional culpability or whether this is the worst of the least mitigated. That term is dicta from U.S. and Florida Supreme Court cases. That's not in the jury instructions. That's not for the jury's consideration. So we would object to that, Your Honor.
And my response, Your Honor, is in the end, they're instructed about weighing aggravating factors versus mitigating circumstances, but in the end, they have to decide what they feel is appropriate. And what I'm proposing, I would submit, is valid argument, and it would be in a general term. It wouldn't be trying to identify specific cases.
Okay. So as the state's motion is drafted, specifically the state requests that the defense not be able, during penalty phase, be able to discuss actual sentences in unrelated cases. So as to just the strict wording of the motion, it's granted. However, that does not preclude any of the defendants from arguing that the facts of this case, combined with their own mitigators, that does not rise to the level of worst of the worst, mandating the imposition of a death sentence. So, generally speaking, you can argue that why it is your client should not be sentenced to death.
Thank you, Your Honor.
Okay.
As to the 6th penalty phase motion, I would have no objection. Would not talk to the jury about prior statutes regarding the death penalty.
Okay, so not
Your Honor,
objection.
as to the state's 5th motion, you're granting the motion as to the defense comparing or regarding the facts or sentences of other specific.
Correct.
Okay.
So there's not going to be specificity, but generally speaking, all of the defendants, if we get there, will be able to argue, generally speaking, why the death penalty is not appropriate for their particular circumstance. Okay, moving on, then grant the state 6th motion for order in limine during penalty phase.
And Your Honor, the state also filed in each of the defendant's cases a motion to compel the defendant to provide penalty phase witnesses and evidence.
Right, and I issued an order setting a deadline for that.
That was met.
Okay. So the motion is granted, and Mr. Hernandez has indicated that he has complied with all deadlines established by the court for Mr. Murphy.
Thank you.
Okay.
I think the language of my response was that I reserve the right to be able to make amendments if so needed, but I don't have it in front of me, but I can tell the court that it was timely responded to.
Judge, I believe did the court's order anticipate witnesses and expert witnesses penalty phase witnesses?
I believe it did. Let me pull it up.
And
that's my understanding.
we did provide
Yeah.
that.
Okay. So the state's motion to compel also contemplates in paragraph 4 a reciprocal discovery as far as records, because I find typically in these cases, as we're progressing through guilt phase, at some point the state's provided thousands of pages of records. That puts us in a very untenable position to allow our experts to have time to digest that information before they conduct evaluations of the defendant. That's the type of information I'm asking for also in the motion to compel.
Right, and in my scheduling order, I gave a deadline for the defendants to all identify any expert witnesses that they intend to call at penalty phase, including the provision of any and all supporting reports, documentation, anything that the experts relied upon.
Our doctor has been listed. He has not provided a report yet. In fact, I think he wants to see him one more time. And Mr. Harmon and I have talked about scheduling his deposition later this month.
Okay, well, I granted the motion, so there's an ongoing obligation for defense counsel to provide reciprocal discovery.
You know, I have 14 motions that I think I can go quickly through, if the court would allow me, because I have them numbered a certain way. The first one is motion to declare sections 921.141 and/or 921.141 subsection 6, subsection H, Florida statutes. It's basically the hack motion.
Okay.
We're declaring that be declared unconstitutional facially and as applied, and I would rely on my memorandum of law.
Okay, that's fine. And just so, Mr. Hernandez, it will make my life simpler, when I was given a list of the pending motions by the state, and they were broken down as far as numbers and when we were going to hear them. So I have them broken down by the dates that we originally scheduled to hear the motion. So, for example, it would be helpful to me, I'm looking at the motions that were initially scheduled to be heard February 26th. And as to Rashad Murphy, the motion to preclude the imposition of the death penalty.
Your Honor, I have them numbered my way. I didn't have them, but I can get to whichever one you want to get to.
Okay.
Which one is it?
It's the motion to preclude the imposition of the death penalty, and specifically that the retroactive application of a death penalty statute enacted in 2016 or 2017 violates Article 10, Section 9 of the Florida Constitution.
Judge, I guess I am having difficulty finding it.
Okay. All right, okay. So, hold on, let's do this. Murphy. Chance. I'm going to pull out all of Mr. Rashad Murphy's motions that I have, and we'll go through those.
I apologize.
It's all right.
I did not have your numbering, and I just numbered them
worries.
separately myself. The first one was the heinous, atrocious, or cruel aggravator motion that I just referred to.
All right, give me just a moment.
And, Your Honor, before I forget, I would request to move orally to adopt any death penalty motions that were filed by co-defendants.
Okay, granted. We have about 60 motions, so just give me a moment. Okay, I think I have pulled out all of the penalty phase motions that were filed on behalf of Mr. Rashad Murphy. So tell me, Mr. Hernandez, which one you want to start off with again?
The first one that I mentioned, Your Honor, was a motion to declare. It's the heinous, atrocious, or cruel aggravator motion, asking that section, those sections of the Florida statute be declared unconstitutional.
What's the actual?
facially
Oh,
and as
here it is.
applied.
Okay. Just making sure. So you're arguing motion to declare sections 921.141 and/or 921.141 6H, Florida statutes, heinous, atrocious, or cruel aggravator, and/or the current 6H interim instruction unconstitutional facially and as applied. Correct?
Your Honor, and I'm relying on my memorandum of law that I've attached, so I don't have any further argument.
Okay, and State, you filed a response to that as well?
We did, Your Honor.
You're relying upon that?
Yes, Your Honor.
Okay, I will deny the motion. Okay, what's
Your Honor,
next?
the next one on my list is titled Motion in Limine Precluding Improper Penalty Phase Argument. And Mr. Harmon has indicated that he does not object to it.
Okay,
Yeah, no objection, Your Honor. We don't plan on making any of the arguments in that
okay, that motion is granted.
Your Honor, number 3, I have motion in limine regarding reference to non-enumerated mitigating circumstances, and believe the state does not object.
We do not object to that motion.
Okay, that one is granted. Okay,
Your Honor, my next one is, number 4, is motion to allow testimony of the impact of defendant's execution on family members. The state, I believe, objects to this one. I think they object to the rest of mine. My argument, Your Honor, to this is the fact that mitigation can be anything. And the fact that he's greatly loved by family members should be something that I should be able to present to the jury. And I would rely on the Lugo case that's in the motion 845 Southern 2nd 74. It's a Florida Supreme Court case, 2003.
okay, Mr. Hartman?
Your Honor, we filed a written response objecting to this. I can make additional argument if the court wishes, but
Well, what is it specifically, Mr. Harmon, are you concerned? I mean, you would concede that obviously the defendant can call witnesses to testify as to the, why it is that Rashad Murphy should not be executed, and that, you know, if he's a good brother or son or provider or whatever it may be, right?
I do.
And so, but I guess where we're having an issue was whether or not those same family members would be able to testify as to their feelings should Mr. Rashad Murphy be executed, correct?
The impact of the defendant's execution, this is a future event that has not occurred. We don't know when it will occur. We don't know if the defendant would even ever be executed or if he would die naturally in the Florida State Prison. We don't know if the family members would still be alive when he was executed. It's just, it is such an unknowable fact for them to testify about. We believe that's improper. I have no objection to family members taking the stand to express to the jury why they believe his life should be spared.
Okay. Let me look at Lugo, and I'm going to take that one under advisement, so,
Yes, Your Honor.
okay? Let you know.
Your Honor, the next one is titled Motion to Declare Florida's Death Penalty Unconstitutional, and in parentheses, it states unreliability. We believe that the argument, Your Honor, is that the fact-finding process cannot be deemed sufficiently reliable to justify imposition of the death penalty, and I would rely on the cases that are cited.
And just to make sure I'm on the same page, motion to declare Florida's death penalty unconstitutional as to unreliability. That's the motion
Yes,
we're
ma'am.
discussing. Okay, and State, you filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny that motion. Okay,
Your Honor, the next one is the it reads motion to declare sections 921, 141, 6I of Florida statute. It's the cold, calculated, and premeditated motion. I'm relying on the memorandum law that I've listed. I'm arguing that the statute is unconstitutionally vague, overbroad, and it is applied in an arbitrary and capricious manner in violation of the 5th, 6th, 8th, and 14th Amendment to the U.S. Constitution, as well as Article 1, Sections 2, 9, and 16 of the Florida Constitution. And I would rely on the cases that are included in the motion.
Okay, State filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny the motion.
The next one, Your Honor, is titled Motion to Declare Sections 921, 141, subsection 8 of the Constitution unconstitutional as requested for proffer of impact testimony and pretrial ruling on whether the danger of unfair prejudice of that evidence outweighs its probative value and or otherwise denies a fair sentencing proceeding. I am basically, that's the objecting to the use of victim impact evidence.
All right, and State, you filed a response?
Yes, Your Honor.
Okay.
We rely upon that.
All right, so I will deny the motion as far as its phrase that the statute is unconstitutional. Obviously, the case law controls how victim impact evidence actually comes in, which we will comply with, but just as to this motion that it's unconstitutional, the provision of victim impact evidence, I will deny that motion.
Thank you, Your Honor. The next one, which is my number 8, motion to declare sections 921.141 and or 921.141(6)(b) of the Florida statutes and to be declared unconstitutional. It basically, the argument in this motion is the prior violent felony aggravating factor of this section should be declared unconstitutional as vague and overbroad and has been applied arbitrarily and in an inconsistent manner, and I would rely on the cases cited.
Okay? Anything further from the State?
No, Your Honor.
Okay, I'll deny the motion. All right, next up.
In our number 9 is a motion to exclude evidence or argument designed to create sympathy for the deceased. I think I believe Mr. Harmon can correct me if I'm wrong. He agrees to paragraphs 1 through 4. I will not be, or that he would not be arguing the victim impact for the purpose of seeking sympathy for the deceased or in support of any aggravating factor.
Okay, Mr. Harmon, anything further?
Your Honor, we agree to paragraph 1 through 4 of the defendant's motion. The evidence designed to create sympathy for the deceased is inadmissible in the guilt innocence phase, and we certainly don't contend on getting into any type of sympathy evidence or argument in the guilt phase. Paragraph 5, we disagree with. The admission of evidence concerning the deceased or the circumstances is inadmissible under Florida law in the penalty phase. Well, that's clearly law. Circumstances of the case to support multiple aggravators in this case will be argued in penalty phase. Evidence concerning the deceased would be victim impact. However, Mr. Hernandez did state as to what I told him that we would not argue victim impact to support any aggravating factor.
That's correct.
Okay. All right. Anything further?
No, Your Honor.
All right. So as to this particular motion, the motion is granted as to items in the motion identified in numbered paragraphs 1, 2, 3, and 4, and it's denied as to paragraph 5. Again, the State is entitled to present victim impact evidence in conformity with the case law.
Your Honor, yes, number 10, there's some repetition here, but it's a motion to limit victim impact evidence, and A through F are the very paragraph or the areas that we're asking for limitations, and we would rely on the case law that's in the motion.
Okay, state what your,
I'm sorry, Your Honor, what is that?
we're on motion to limit victim impact evidence, and
Yeah.
specifically, they're requesting only one witness may testify. The witness must be an adult. The state must proffer a proposed victim impact statement in writing. The court must hold a hearing on the admissibility of the evidence prior to its admission, and the court must consider relevant case law. The testimony must be limited to the prepared statement. No witness may testify if the witness is unable to control his or her emotions.
So Judge, we objected to the remainder of the motion, including that portion. Limits on victim impact on one witness, that's not supported in the case law. There are cases where up to 12 witnesses have been allowed, 12 impact witnesses, even more in some cases. In this case, I'm not sure how many we would call. I know the court is aware we normally try to proffer impact through written statements by the family members. But there have been cases, I have presented the impact statements in the past from the community to include friends, family, in-laws, things like that. So I don't believe that these limitations are.
Okay, so you object to only one witness, correct?
I do, and I object to limiting age, that type of thing.
So you object to the witness must be an adult?
I've never called anyone other than an adult in impact. I don't believe in this case that's an issue.
Okay. What about the state must proffer a proposed victim impact statement in writing?
We normally do that, Your Honor, just I believe it works better that way.
Okay.
The pretrial rulings on the admissibility, so I have no objection to that, I guess.
Okay. The testimony must be limited to the prepared statement, right?
Yes.
Okay.
Yes.
And you agree no witness, either for the state or the defense in penalty phase, can testify if they cannot control their emotions,
I
right?
do agree, Your Honor.
Okay. So as to Rashad Murphy's motion to limit victim impact evidence, it is denied as to paragraph A, and that only one witness may testify. However, if we get to penalty phase, Mr. Hernandez, if you want to renew an objection, if the state, you think, is intending to call too many witnesses for victim impact, then you can renew your objection at that point in time, once we get down to the
Yes,
actual
sir.
evidence that's coming in. But generally speaking, paragraph A is denied. At this point, I'm going to grant paragraph B, that the witness must be an adult. Again, if for some reason we actually get to penalty phase and the state intends to call a minor, we just need to talk about it before you do it, Mr. Harmon.
Yes, Your Honor.
C, the state must proffer a proposed victim impact statement in writing. That's granted, and that victim impact statement needs to be provided at least 24 hours before the witness testifies. So that way, if there's a problem, we can discuss it. All right? I will agree to hold a hearing on the admissibility of the evidence if there's a dispute. Okay, so that's granted. Paragraph D. E, the court must consider relevant case law. I concur, I must, so that's granted. And the testimony must be limited to the prepared statement. That's granted. That's paragraph F. And paragraph G, no witness may testify if the witness is unable to control his or her emotions. So that's granted. Okay?
Your Honor, the next one, number 11, is a motion to preclude application of the most recent amendments to Florida Statute 921.141. In this case, as such application would violate Florida Statute 775.022, where our position is, Your Honor, that for the death penalty to be imposed, there should be a unanimous 12-0, and as opposed to an 8-4.
Okay. State, you filed a response. You relying upon that?
Yes, Your Honor.
All right. I will deny the motion.
Your Honor, number 12 is motion to preclude imposition of capital punishment on the ground that the death penalty is presently administered as per se cruel and unusual punishment. And I would rely on the memorandum of law that is attached.
Okay, and state, let's see, you filed a response, are you relying upon that?
Yes, Your Honor.
Okay, I'll deny the motion.
The next one, Your Honor, number 13, is a motion to preclude the imposition of the death penalty. And again, I would rely on the memorandum of law that is attached.
All right, state you filed a response, are you relying upon that?
Yes, Your Honor.
Okay, deny the motion.
And then finally, Your Honor, a request for jury instruction. It is our position that in order for an aggravating factor to be considered by a jury, it should be beyond all doubt, not just reasonable doubt, and we're asking for that jury instruction, and I would rely on the case law submitted.
Okay, state you filed a response, you relying upon that?
Yes.
Okay, I will deny the motion. That's all I have for you, Mr. Hernandez, for Rashad Murphy. Is that all you have?
Yes, Your Honor. Thank you. That's all I have.
Okay, very good. Okay, so let's go back to Mr. Gathrights' motion to suppress. Mr. Wise.
And Your Honor, which would you like to
You pick.
address first? Okay.
You tell me.
Well, I have looks like the traffic stop first on the pile, or not really the traffic stop. This is really a multi-layered
Right.
motion, of course. But this is a motion to suppress all the evidence that comes following the traffic stop of Mr. Gathright. And our first layer is that the stop itself was illegal. Obviously, everyone pretty much recognizes it was a pretextual stop. I recognize, of course, that pretextual stops are legal as long as there's an objectively reasonable basis for the stop. The problem here is that there was not. The two officers who conduct the stop testify that it's based on speed and intent. Now, they clearly have every intention to stop Mr.Gathright's car. Detective Barry is actually in the criminal apprehension unit, which apparently his main job is to conduct stops like this. Despite all of that, neither one have a dash cam in their car. No one has a radar gun or any kind of way of clocking the speed. They both testify as to the speeding, that they estimate the speed, but they've only seen the car for a quarter of a mile, approximately. Neither one of them, even today, can testify as to what the speed was on the road where they conducted the stop. They said 35 to 45, but neither one of them even knows what the speed was. And just the same, neither one of them knows what they thought Mr. Gathright was going at the time. So under the circumstances, Your Honor, particularly given that this was a plan all along to make the stop, this is not an objective, reasonable basis for the stop. And even though estimating speed can be a basis under Florida law, the Allen case that I discuss in the memorandum says the estimate has to be reasonable and credible. And in this case, under these circumstances, it's not a credible estimation of the stop. The second basis for the stop, the tent violation, is also not an objectively reasonable basis. And I have a couple of statutes I had not cited in the memorandum, but I can provide. If you'd like me to approach, I can cite them.
Sure.
But it's really just two traffic statutes that pertain to tent violations.
And for the record, you've handed me 316.2954 and 316.2951.
Yes, sir. And here, again, at least Officer Baer, I can't recall if Detective Griffin claims he sees a tent violation as well. I think he may have. But neither one of them end up measuring the car. Someone else does. They don't know what the reading was. But in any event, Detective Barry issues a citation for a tent violation at some point. But he issues it, as he testified, for the tent being less than 15%. The problem with that, Your Honor, looking at 316.2954, it states, for most cars, I guess you could say, that is the law. If it's less than 15% in the visible range, that's a tint violation. And that's what apparently Detective Barry relied on. But it makes an exception for what are clearly SUVs, and the officers testified, and I think everyone knows a 4Runner is an SUV, but one of them testified to that fact, that something that qualifies as a multi-purpose passenger vehicle is allowed to have rear windows that have a light transmittance of at least 6%, so substantially lower threshold than the 15% that's most applicable. And then looking at the other statute, 316.2951, it defines what a multi-purpose passenger vehicle is, and I think that clearly is a sport utility vehicle.
Well, it says 10 persons or fewer.
Yes.
Does that include a,
The way I interpret it, Your Honor, it can be, it's 10 or fewer if it's constructed on either a truck chassis or has special features for occasional off-road operation. The statutes do not, as I see, define sport utility vehicle. I think that definition clearly would encompass a sport utility vehicle.
a 4Runner, a Toyota 4Runner can carry 10 people legally?
Well, 10 or fewer. I don't think that it has to be, if it were 10 or more, I think that'd be problematic, but it's 10 or fewer constructed on either a truck chassis or for special features for occasional off-road operation.
Okay.
So in any event, I think that encompasses what a 4Runner would be, and that pertains to, when you read in conjunction with 316.2954, it allows for tent to be 6% or higher. So clearly, I think the officers, well, I quite frankly think it was a pretext. It was a case of stop the car and figure out a reason later, but in any event, it wasn't objectively reasonable because I believe they were relying on the wrong statute regarding the tent violation. Next layer, though, would be the search of the car, of course. And I believe there really are two issues with regards to the search. Number one, Detective Griffin is the only one who allegedly smells the scent of marijuana. I don't believe that his testimony in that regard is credible at all, based on what you saw last week. So he stops the car, is talking to Mr. Gathright at the car window for quite some time. Detective Barry also comes to the car window to get the license. Detective Barry never smells marijuana. Detective Griffin, after some time talking with Mr. Gathright, claims to have smelled the scent of marijuana. He says, in his own words, it was a faint smell. You can't distinguish between whether it's fresh or burned, but he claims he smells marijuana. When the car is actually searched, there is a small amount of residue in a sealed mason jar. The quantity is too low to even be able to try to weigh it. There's no presumptive test performed on it, probably because it's of the small amount. It's in a sealed mason jar in a sealed backpack inside the car. There is no way that could be giving off any kind of odor of marijuana to be detectable from outside the car. And there's no indication, he testified he doesn't see any signs of impairment on Mr. Gathright. You can't say that it's a smell of burned marijuana that might have taken place, you know, if someone smokes in the car sometime earlier and then drives. He says it's a faint smell of marijuana. The facts just don't support his claim that he smells that from outside the car. But number two, even if he did, the law has changed considerably in the last several years, and the Williams case in particular that was issued back in the fall recognizes that there are numerous forms of marijuana or of the cannabis plant that are legal to possess under state law and federal law. Anything basically that qualifies as hemp under state or federal law looks like illegal marijuana, smells just like it, and no one can determine which it might be just based on the smell. Aside from that, of course, under state law, medical marijuana can be lawful in certain circumstances, and for a time it appears this Delta-9 marijuana was lawful to possess. But in any event, the hemp is lawful under both federal and state law, and no one can really distinguish between the two. And that's why the Williams case has now held, similar to Baxter in the 5th District, I think the year before, that the odor alone is not enough to support stopping. Now, what happened in Williams, and I'm sure the state's going to argue that, is that in Williams they found that even though that's the law now, when the search was conducted, we had a different precedent. So they said that the officers acting on good faith reliance could do that. Here, the problem again, aside, just for the record, I would argue, saying that good faith reliance is okay really doesn't make a lot of sense in this situation because the laws that the DCA has recognized changed, happened long before this search was conducted. So I don't believe that it actually is reasonable to say officers should have been able to rely on prior precedent when the laws that legalize forms of marijuana were in existence. But the other problem in this particular situation is I don't believe officers were acting in good faith. We know very well they were looking for any reason to conduct a search of that car. I would suggest to you this is a classic case of we'll search first and we'll figure out justification later. I guess you could say luckily, but there was some little form of marijuana found in the car that they could rely on. But clearly, under the totality of the circumstances, this search is being conducted because they want to find evidence from this case, and they're going to find a reason later. And they find that little bit of residue to justify it. It's not good faith reliance on prior case law. The next level, Your Honor, of this motion is assuming, hypothetically, that the smell of marijuana would give the reason to search the car. Law enforcement goes far beyond searching for potential marijuana and more importantly, in what they seize from the car. Law enforcement seizes these casings from the car. They're not unlawful to possess, just like the rifles. Now, there's a claim that handguns could not be possessed because of Mr. Gathwright's age, but there's no prohibition on possessing fired casings. There's no prohibition on, even if they're for a handgun. There's no prohibition on rifles. There's certainly nothing illegal about the laptop and iPads he possessed, but all of that is seized from the car based solely on this scent of marijuana. Now, we know very well why everything was seized, but there has to be an objective reason to do it, and there wasn't, especially for fired casings. I mean, he's not a convicted felon. There's no reason he couldn't possess those to begin with. Last layer of the search, or of the motion rather, is all of this evidence is then used to get the search warrant for Mr. Gathwright's house. I think everyone who testified about that agreed that search warrant would never be sought even. It certainly would not have been approved, but for the evidence that's found in the car. I recognize, and I'm sure the state will point out, that search is being conducted by Jacksonville officers regarding really, it would appear, I don't even think it was the earlier Charles Jones shooting. It was another shooting they linked to casings that are found. But what's significant is they still seize substantial evidence that they're trying to use now in this case. And that would never have happened but for the illegalities that occurred during the traffic stop. And I believe even though it's conducted by Jacksonville and the warrant is sought in connection with a different case, it's clearly a fruit of the poisonous tree because but for the illegal stop, the illegal searches, there would never have been a search of the house. And I believe those cover all of the bases that I'd be relying on for this motion.
And you mentioned it, and I just want to make sure we're on the same page. You concede that the second DCA in Williams, they actually affirmed the trial court finding specifically that the law in our district at the time of Mr. Williams' arrest and Owens was the law in the second DCA at the time of Mr. Williams' arrest, and it expressly permitted the search based solely on the odor of cannabis. Thus, by following Owens, law enforcement was acting in objectively reasonable reliance on binding appellate precedent. We therefore affirm.
I certainly agree that that's what the second DCA
Okay,
concluded.
and that the arrest in this case and the search of Mr. Gathwright's car occurred prior to the Williams opinion being issued, correct?
That's correct.
Okay. Okay, Mr. Rice, thank you.
And Your Honor, the state is relying on Williams v. Florida, that second DCA case as well. It is clear that there was a objective legal basis to stop that Toyota 4Runner in Jacksonville. You heard from 2 law enforcement officers from Jacksonville who were in separate vehicles, who both are trained and certified in estimating the speed of a vehicle. They both obtained that week-long class where they were able to demonstrate that they were able to accurately estimate vehicles within 5 miles, tested against a radar gun. They both had that training. They both passed that training. And with regards to Detective Griffin, he says that he still utilizes that training and makes that type of estimation 1 or 2 times a week as part of his duties in his present job. And they both estimated that the defendant was speeding. They chose to just give him a warning in that instance, so that there were 2 bases to believe that the defendant should be stopped. The other one was that tint, and you heard that he was actually given a citation for that based on another detective coming out there. They actually came and they measured the tint, and that was within the range that was not valid, so that he was issued a traffic citation stop based on the illegal tint that SUV had at the time. So there was a reasonable basis to do that. And you heard from Detective Griffin that he smelled the faint odor of marijuana when he was standing at that vehicle. Officer Berry had already taken the license at that point and had walked away. And based on a search of the vehicle, based on the smell or odor of marijuana, they indeed found marijuana, which again goes to support that that was a credible observation by Detective Griffin, that he actually did smell the marijuana and was able to conduct a legal search of that vehicle. In searching that vehicle, any place where you could find marijuana, he found a handgun. And the defendant was 21, under the age of 21 at the time, and the defendant was arrested for 2 bases, based on possessing the marijuana and drug paraphernalia, as well as a person under the age of 21 possessing a handgun. Those were bases to arrest the defendant and conduct a inventory search of all of the vehicle. And you heard that it is protocol whenever not just a firearm, but any sort of ammunition or parts related to firearms, when they are found in a vehicle, regardless whether it's a search warrant or an inventory search, all of that gets put into NIBIN as part of their procedure. And it is the NIBIN results that lead to the search warrant, a properly executed search warrant of that house in an unrelated homicide investigation, which provides for all of the evidence then that is related in this case. It really does turn on the traffic stop, and there was a reasonable basis for law enforcement to stop that vehicle and then conduct the search that they were able to find all of the other evidence in the case. So, Judge, if there is a reasonable basis to stop, and we rely on the Williams v. Florida case, which was decided in October of 2025, where they said that no longer would you be able to use the smell to justify a search of the vehicle, but good faith reliance on binding precedent at the time, which was October of 2025, they're not going to suppress any evidence based on a search based on smell. And this search happened the year before. So we would ask that as well, Judge, that good faith reliance, that was binding precedent, that was the law at the time of. Law enforcement was able to conduct a vehicle search of Mr. Gathrights' Toyota SUV based on that odor and smell of marijuana. He went into his credentials, his familiarity with that smell, and that search did in fact lead to marijuana within the vehicle. So based on all of that, we'd ask you to deny the defendant's motion to suppress.
Okay, Mr. Wise, any rebuttal?
Just briefly. With respect, I recognize at least one of the detectives, I think they both talked about this, the class that they'd taken. And they may be qualified at times to make traffic estimations as far as the speed someone's going. But the problem is it has to be reasonable and credible. That's what the case law says. You can estimate, but it's got to be reasonable and credible. And that's the problem here. It's observing for a quarter of a mile, can't even say what the speed limit is, even to this day. Can't remember how fast they thought Mr. Gathright was going. So I would suggest, even though maybe they're qualified under some circumstances to make the estimate, we don't have the evidence here to support that, to show that it's reasonable and credible. Again, as to the tent violation, it's measured, but no one last week had even testified what the measurements came out to. And I believe, as I pointed out, I think they were relying on the wrong statute quite clearly when they were reasonably, in their minds, objectively determining that the tent was not lawful. Williams, again, before obviously reaching the point where Williams would come into play, there has to be a finding that the smell, that the testimony you heard was credible, that the officer actually smelled the marijuana. I don't believe that finding can be made given the testimony from last week. But even if it could be, I obviously don't agree with Williams and their conclusion that they should rely on it. But this isn't a situation, even recognizing that holding, where the officers are relying in good faith on Williams. They're trying to find any reason they can to justify the search. And they clearly, obviously it's a pretextual search. No one's really disputing that. But it makes no sense for them to come back and rely on Williams after finding this little bit of residue. With regards to the casings being placed in the NIBIN and the various other firearm evidence being collected, that's a seizure. And I don't believe that there was a lawful basis, given Mr. Gathright is not a convicted felon, to seize casings from the car and put them into NIBIN. That goes beyond searching for marijuana. It goes beyond even an inventory search. That is a seizure.
What's your position on whether or not there was probable cause to arrest Mr. Gathright for the for the gun that was found in his car, and he being under the age of 21?
Well, they don't do that, I don't believe. And under the circumstances, I can't agree that that would give probable cause alone to arrest him for that. We don't know. Sorry. To arrest him for that. The car, for what it's worth, is registered in his mother's name. His mother is a retired Marine. The handgun is not in plain sight. It's deeply concealed within the car, so I don't believe there was probable cause for that.
Okay.
But again, even then, the NIBIN hits, the last argument I think the state was making, the NIBIN hits didn't provide a lawful basis to search the house because there would never have been NIBIN hits if it weren't for all these illegalities that led to the NIBIN hits.
Okay. I understand. Thank you. Okay, I'm going to take it under advisement. I'm going to do a written order. All right, so then we have Mr. Gathwright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
So this is a much different motion, obviously, Your Honor. It probably became apparent last week that I was a little surprised by some of Detective Ramos' testimony. That may not have been apparent, but I set out in the motion, and I was intending to argue that what I believed was a date range, a temporal limitation in the warrant, was overbroad. And from Detective Ramos' deposition, in all fairness to him, he couldn't really remember every search he conducted because he conducted many searches, but it was that if there was a temporal limitation, I would have stayed within it. Clearly, he did not. He testified last week he had no intention at any point of limiting what he was going to search from the iCloud, and he clearly did not. He searched the entire thing. That's what he testified to last week. That, Judge, I don't even know that it can be questioned that would not violate the particularity requirement of the Fourth Amendment. This is an evolving body of law, but the cases that have addressed this, several 11th Circuit cases, and then I think the Demons case is probably the most on point state of Florida case, they recognize going in and searching someone's iCloud account is the equivalent of a general warrant. It's just rummaging through basically their life. In this case, it was rummaging through almost 4 years of Mr. Gathwright's life. That's why a lot of this goes back to the McCall case from the 11th Circuit, and Demons relies on that, but there have to be temporal limitations on what is being searched when a warrant is being sought for something like an iCloud account. In reading the warrant and the affidavit that Detective Ramos drafted, it could appear that there is a date range of June 1st, to July 12th, 24, which I believe even that would be substantially overbroad under the current case law. But Detective Ramos stated he was not limiting the search to that date range, and he had no intention of doing that. It sounds like it's somehow auto-populated that he did the affidavit. And when he submitted the request, and in the warrant that was actually signed, it basically provided free reign to review the equivalent of everything that was in the iCloud account. All emails, all instant messages, all iCloud data associated with backups, all contacts, all records and information regarding locations, all data stored in location services, all records pertaining to the type of service used, records of games, videos, other remotely accessible data, and the associated IP addresses, all files, keys, basically anything you could think of that could be in an iCloud, he includes in this affidavit and in the warrant that he drafts. Even if that's problematic in itself, even if we have a temporal limitation of a month and a half, but there was no limitation whatsoever. It essentially went back to March of 2021.
Well, didn't he testify that Apple just gave him everything?
They did, and I think in the deposition that's what he thought happened. And even if that's the case, Apple clearly did give him everything, and it's addressed in a couple of the other cases I'll get into, but even if that was the case, then he would have a reason to limit it to whatever dates were in the warrant. So even if arguably this could be read in the warrant as a temporal limitation, which he apparently did not read it as, then he has a duty to confine what he searches to that. And I asked him about how, wouldn't it be easy to just click on the last access date and it organizes everything by that date? You can search only things within that date range. But he had no intention of doing that. He looked at the entirety of the life of the account, almost 4 years worth of material, at least 3.5. So even if that was a limitation, and even if Apple ignored it, he made no effort whatsoever to limit what he actually searched. That, Your Honor, I think clearly violates the holdings in Blake, which I think is the probably the main 11th Circuit case that addresses this. In Blake, they addressed two different warrants. There was one to, I think it was Yahoo. There was one that they found was not problematic, although it appears in reading Blake that they were that was even a close call. But then there was a Facebook warrant in Blake that they found far exceeded the particularly requirements of the Fourth Amendment. This one is just like that. It really had no temporal limitations, and it had no categorical limitations. It was what they found to be the equivalent of a general rummaging warrant. I don't know if the state, really can even argue that did not violate the Fourth Amendment, especially the way the warrant was executed. But I think a big issue now that's addressed in the Demons case that I cite is, according to Demons, there can be an attempt to try to, I think, basically parcel out what was unlawful, what went outside the temporal limitations, and focus on what may have been reasonable. They did that in Demons, but they also said that it's not always going to be appropriate and not always going to be feasible. In that case, and unfortunately in Demons, they don't really they don't talk about why that warrant was overbroad. It appears the state agreed it was overbroad, but then they made an attempt to limit it to information from the time of a shooting that was being investigated and a few hours before and after. But in reaching that point, they noted, relying on a couple of federal cases from other circuits, one being Gulp and the other being Pilling, which I have a copy of, but they said that even when parts of a warrant may be valid and distinguishable, severance may be appropriate if the sufficiently particularized portion is only a relatively insignificant part of a sweeping search, or where the warrant is generally invalid but has some tangential item that meets the requirements of probable cause. The problem here, Your Honor, is it's far from a relatively insignificant portion of the warrant, whatever might have arguably been relevant, because we have, again, 3.5 years worth of Mr. Gathrights' life that is collected in this iCloud. And really, based on Detective Ramos' testimony, there was no significant limitation that he could establish that might have been lawful. And even if there had been, he completely ignored it and went far outside of whatever limitation it might have been. I had been prepared to argue that June 1st to July 12th was substantially overbroad because it encompassed far more time than this conspiracy could have even arguably existed. And we went back and asked when was this first advertised that there would be a Charles Jones show in Tampa, and that was June 14th. So anything before June 14th could not have impacted this, could not have been evidence of the conspiracy because there could have been no conspiracy. Nobody knew Charles Jones was going to be coming here until June 14th. The evidence or the facts set out in the affidavit are really pertained to actions that occurred from June 22nd to June 28th. In any event, nothing before June 14th could have been relevant. Yet, this goes 2 weeks before that and then goes substantially beyond the time the conspiracy was alleged to have existed. Under the circumstances, Your Honor, and I would I cite to most of the cases I'm relying on, but the one that I didn't cite is Pilling, which I have a copy of.
Okay.
It's referenced in Demons.
Okay?
It's a district court case from Idaho, so obviously not binding on us, but it's a very, very similar circumstance that they dealt with. And that one, and Demons, I believe I said, also relies on that. But in that one, basically it's the same thing. They get an entire Apple iCloud dump. Apparently there's some discussion about, there may have been some attempts to purge the information that would have gone outside the relevant limitations, but it states, and this is on, I believe it's the third page of the printout, that the government realized it inadvertently failed to purge the data, and essentially everything ended up being looked at. It appears that was done accidentally. Here it was done intentionally. But in any event, they go forward, find that the warrant was substantially overbroad, just as we have here, and then at the end of the case, the last 2 pages, they discuss why severance can't apply in that situation. And similar to what the court found in Demons, they're saying that you can't sever this because of the relative size of the valid and invalid portions of the warrants. And the portion that might arguably have had some relevance was relatively insignificant given the substantial size of the information that they had. Then they go on to conclude the opinion by finding additionally that the suppression was also justified because the government did not filter any of the unresponsive data before reviewing the defendant's entire iCloud account. And that's exactly what happened here. Even if in Pilling there was some attempt, there was no attempt whatsoever here. As Detective Ramos' testimony established, he had no intention of limiting anything. He was looking at everything that was going to be in that iCloud. And he did so. And I think the substantial portions of what he took out of that he finds to be relevant would have been far outside even the date range in this search warrant. But he didn't confine himself to that in any event. Good faith exception is obviously something that may be brought up. I don't see any way the good faith exception can apply here when the detective drafts a search warrant affidavit that he himself says he has no intention of limiting to any kind of temporal limitation. So even if the court arguably saw this to be a temporal limitation, it was essentially Detective Ramos deceiving the court because he said in his own words he had no intention of limiting what he was going to look at. And then even if the court did, issue what it believed to be a good faith warrant, Detective Ramos had no intention of following the limitation, and he didn't. He went far outside of it. I would suggest, Your Honor, even the date range of 6/1 to 7/12, in light of Blake and the other cases that we rely on, that's a facially deficient warrant. But regardless, Detective Ramos, number one, had no intention of the court limiting it to that date, and he had no intention of abiding by those dates. So I don't see any way the good faith exception could apply.
Okay, thank you, Mr. Wise. Ms. Ismer, why should the state not be limited to the dates of June 1, 2024 through July 12, 2024?
Number one, because the return was
accurately complied with by Apple and Detective Ramos, but also because in the months leading up to the incident, several of the items of evidence that were discovered within the time frame that's listed in the original warrant date back to or in some way connected to evidence that's also located on the device in the months before. There were several representations by the defense that Detective Ramos nor Apple abided by the warrant, and I believe there was some insinuation that there was misconduct or an ill intention by Detective Ramos. But if Mr. Wise has read the content of the search warrant, including the probable cause affidavit, what Detective Ramos requested was included in his request were the iCloud backups from both of these accounts from Mr. Gathrights' devices. And that is exactly what Apple provided. When he backed up those devices between June 1st and July 12th, the information from the months prior were included in that backup. So yes, that is what was provided to Detective Ramos. There was also the reason for requesting such information also testified to by Detective Ramos, because oftentimes those items are either mislabeled, not labeled, and now with Apple's ability to actually change the date and time on photos and videos in devices, they make requests that specifically cover that type of occurrence happening. So it's not an overbroad warrant, but more specifically, the time frame from before the offense itself has several links to the temporal timeline that was provided of June 1st to July 12th. The specific example that we gave, or at least I asked Detective Ramos about, was in particular a photograph that depicted two separate rifles or assault rifles on the ground. The photograph, as it was discovered in the device of Rashad Murphy, that had been previously discussed, was sent to Rashad Murphy's device from Sean Gathrights' device within the temporal time frame that was listed in the warrant. But that photograph actually originated when you selected it or clicked on it in Mr. Gathrights' device, having been received at a time in March of 2024. And so when you actually open the file and look to created by modified date, you could see the trail of where that photograph came from, and it would certainly be relevant to this case. Neither Apple nor Detective Ramos actually violated what was requested in the search warrant or what was actually disclosed or provided in the data that he received. So in looking through the data or the backup that occurred between the temporal timeframes that were listed in the search warrant, which again is also not overly broad given what's been stated and the evidence that they had at the time of the premeditation leading up to the offense itself, and then ultimately the flight from and attempt to conceal their identities thereafter, it's an appropriate timeline of evidence that they were seeking. Several of the Jacksonville detectives also testified about their having seen visually several of the defendants or the defendants getting into it with the victim in this case in advance of his homicide. And so having a time frame which spans before the offense itself and thereafter not only provides a full picture of all of the data that's relevant to the case, but also the relationship of that device and if there are changes. Does this device typically stay in Jacksonville? Did it travel to Tampa on this weekend? You're not only establishing direct evidence from the date of the offense itself, but also the pattern activity for that device as well.
Okay, so if I'm understanding you correctly, so the photo of these firearms that was on Mr. Gathrights' phone, it was originally received on his phone in March of 2024?
Yes, March 27th of 2024 from Isaiah Chance's cell phone.
Okay, so Isaiah Chance sends a photo of Isaiah Chance sends a photo of Mr. Murphy or Mr. Gathright?
Isaiah Chance sends a photo of two firearms on the ground, rifles on the ground, to Sean Gathright.
Okay.
That photo is then sent from Sean Gathright's device to Rashad Murphy's device in June.
June what?
June 20th of 2024 at 3:02 a.m.
Okay. Okay, and so if I'm understanding you correctly, so in the temporal time limit of June 1, 2024 to July 12th of 2024, so the subpoena goes out to Apple, and then they send in everything that was on the phone during that time period, or that account during that time period, plus any backup. So anything that was backed up during that time frame also gets produced, correct?
Yes, they would not have what's on the physical device. They would only have the backups.
Okay.
Because it wasn't a search warrant for the physical phone itself. Only whatever went to the cloud,
Right.
this, storage location. They would only have, if the device was backed up, whatever that file was and the dates of the backups. So they could
Okay.
only provide or produce backups in the timeline that they were given in the search warrant.
Okay, but that then kind of becomes a dragnet that brings in, even though you're putting a temporal time limit on this application for the warrant, and that's what the judge signs, and that's what the warrant says, nonetheless, because if the device or if the iCloud accounts are backed up during this temporal time frame, then everything that was in the accounts now gets brought back in, correct?
Correct.
Okay. Okay.
The reason it becomes relevant, Your Honor, is for several points. If a file is deleted or altered in some way, it would not have a time frame linked to it. So that would come with the backup. We would often be able to see it if it's deleted and not overwritten. But if it is, sometimes you can't see the file, or sometimes you can say where it says deleted and can't open it. But those actions are also relevant if files are deleted at or near the time of the offense itself. Then the files that link back to the prior incidents, if they are linked to the data that's provided to the offense in some way, that photo I'm talking about from device to device between the defendants being one of the relevant examples, that is an argument as it relates to weight and relevance for the defense to make. The fact that we can trace that photo back from before this temporal time frame doesn't make it inadmissible evidence as a result of what was disclosed to us. When you open the file, if created date, modified date, and last access date, because you received the photo of guns 3 months ago but sent them 3 days before the murder, certainly those are relevant to the case. So selecting that image, just because the data is dated before the time frame included in the warrant, it's also relevant and related directly to the time frame that we have.
Right. Now, I understand why the evidence would be relevant. I understand that argument. I guess the question I have is, if the state has the ability to acquire all of the evidence in someone's iCloud account because a backup occurred during the time frame, then it kind of makes the time frame meaningless. There is no time frame, because then if the backup occurred, now law enforcement gets everything just by virtue of the fact that the backup occurred during the time frame, and so then, which makes the temporal requirement then really irrelevant.
If the court is presented with those items that the defense seeks to exclude. So had the state presented to you photographs which we could establish based on the electronic data that dates had been changed on to before the offense, or that had been deleted, the court would have to look to those items to determine whether they were within this time frame, whether there was something in those photographs which allowed us to date it, or there was some evidence of them having been modified, which is why we would not exclude all of the evidence, but instead the defense would have to at least specify which items they are indicating are outside of that.
Okay, are you prepared to do that, Mr. Wise? Are you prepared to make the argument that specific items of evidence are outside of the time frame on the subpoena and therefore shouldn't come in?
I certainly would have been, Your Honor. One of the things I asked to take from was came up in his depo was, he claimed there were photos where Mr. Gathright is making what he believes are gang signs. In my review, I don't think any such photos would have been within this time frame. So I asked him again last week, which ones are you talking about? Because I'd like to try to identify. This has almost 14,000 photographs. And so it's not something I can do easily, but I've parceled out the ones that I think might have a gang sign. None of them are in that date range. So short answer is yes, Your Honor. again, I don't think this is severable. I think the entire thing should be suppressed, but even if
No, I understand.
Because it's limited, yes. I mean, I'm gonna ask the state to establish a basis for every piece of evidence from that iCloud to show that it came from whatever the court finds to be the appropriate date range.
Yeah, okay.
And, like, I can add my rebuttal, but
Yeah, no, I hear you, and I'm probably asking the wrong person. So shouldn't it be your responsibility to identify what items of evidence, assuming I find the time frame of June 1 through July 12th to be appropriate? Just assume for the sake of argument I do. Wouldn't it be your responsibility then to identify what items of evidence the state would intend to admit at trial, and then I would hear argument on whether or not that would be admissible? Wouldn't that be your job to do?
Well, at this time, Your Honor, the state's position is that the items that have been received in the response are admissible items. If the court is limiting the state's date range, then the state would obviously assert that the dates that are provided in the warrant are more than satisfactory based on the probable cause that's stated in the warrant. The issue then becomes the images that can be connected to or dated back to the other evidence in the case. So there are ways that the state can articulately provide those items, meaning we just have an evidence view of those items sooner rather than later, and certainly we can do that as it relates to the iCloud account for Mr. Gathright, if that would be beneficial to Mr. Wise, but nothing about that type of evidence view would change the state's position specifically as it relates to the time frame that's listed.
Okay. Okay, all right. Ms. Wise, any rebuttal?
yes, I think it would be. One,
I certainly disagree that Detective Ramos and Apple did not violate this warrant. I think Detective Ramos' testimony last week, he more or less admitted it. I mean, he did admit it. He said this basically auto-populated, and even if that was, which I think is reasonable to read that as a date limitation, and I think Judge Smith likely did.
Right.
But Detective Ramos sure didn't, because he said himself he went far outside that. And with respect to the backups, if an account is backed up, it may be relevant to see evidence that it was backed up during that range, but that doesn't just open the door to look at everything that was on the backup. Because if we're doing that, I mean, what's the point of putting any limitations in this warrant?
That's my question.
Right. So I don't see how. Again, the fact that it's backed up, sure, that's relevant. If you find that the warrant's severable, but that doesn't open the door to just look at everything in there, and that's what happened. In looking at the hard drive that I have, it doesn't distinguish that I can tell, and I'm far from a tech expert, what was the backup and what was not. It gives two accounts, which are the two that are in the warrant, and I don't see how it distinguishes between what was backed up and what wasn't. It's just everything. And that includes almost 14,000 photos, 400 and something live photos. I can't remember how many videos. I believe a few hundred, if I recall. It's his life for 3.5 years.
Yeah,
I'm
no,
not
I hear you.
exaggerating. One thing I would add, and I recognize if the court finds some temporal range to be appropriate, I agree that if there's a photo maybe that's older that is sent during that range, that may be lawful under the warrant. But the problem is, and it's very easy, by the way, to do that, as Detective Ramos testified. You've got categories. You can click last access, date created, last modified. You can sort them all that way. It takes a long time because of the data for it to populate, but it's as simple as clicking a button. So it's pretty easy, I believe, to determine what would have been at least accessed during that range. But that doesn't open the door to going down trails that take it far outside. I mean, if a photo is from 2021 and it's sent during, June 24th of 2024, and the court finds that appropriate, I agree that would be within the range, but you can't keep going down rabbit holes and going far outside the range, and I think that's the problem. One thing I would point out, because I know it was brought up that, there may have been something that Jacksonville detectives knew. Obviously, the search warrant affidavit is confined to what's in the four corners of the affidavit, so I don't believe that, if there's other evidence Jacksonville knows would give a reason to go outside the warrant if that's not something that's included in the affidavit. I've given my reasons. why I don't believe this is severable at all, but I think even if it is found to be severable, this date range, and this is what I was prepared to argue before last week, is overbroad as it is. Again, anything before June 14th, I think, could not be relevant. This has a month-and-a-half range, far beyond what they found in Demons to be appropriate, which was just a few hours before and after a shooting. So in no way am I conceding that this warrant is severable at all, but even if it is, the date range we have is substantially overbroad, and I believe would be a violation of Blake in the many cases that it addresses.
Okay, interesting. All right, I'm going to take this one under advisement as well, but State, if I were you, I would start looking at the items of evidence that you would specifically intend to introduce. And if it was outside of the date range that was in the warrant application, which would be June 1 through July 12th of 2024, and the only reason law enforcement gets a hold of it is because the account was backed up, that's the only way they get it, you all need to start looking at what items of evidence you would actually intend to introduce, and you need to have an argument as to why. Okay? If I were you, I'd start doing that. Okay? All right, very good. I think that's it on the motions to suppress, correct?
Yes, Your Honor.
Okay. All right, it's 12:06, so let's go ahead and take our lunch recess, and we will reconvene, let's say 1:40, and we will continue on with the penalty phase motions.
Unless they just like, not do like.
Put it on the docket, Monday the night.
Because, initially, because they do that, because they're going to state court.
I don't argue that motion.
Right.
Well, what about number 9? I don't argue that either, y'all. I got number 9 here, y'all. State my object, but I don't. Well, hold on, Daddy. Hold on, Daddy. Can we do all of them?
But you're doing that also.
I need him to say about it. He at the house right now, sitting with my dick. And the leg propped up. Knees hurt this morning. My boy. Just, hold on, let me catch up. He was almost 13, y'all. My 13. Yeah, he was all there. I was all over the place looking for him. Look at y'all in here. I'm one of these. Look for this. Slow down, boy. Yeah, we should have. We could have been done by. We could have been done by. I need him to stand in. Remain seated. Come to order. Court is now back in session.
Okay, good afternoon. We're ready to move on, or move, I guess, back to the penalty phase motions. And I did take a look at the scheduling order that I entered, and the defendants were supposed to have disclosed all penalty phase witnesses, including expert witnesses, by November 17th of 2025. For any expert witnesses, the defense must also disclose any and all records relied upon by the experts in reaching their opinions, as well as any reports issued by the same expert witnesses, and the state had until December 15th of 2025 to disclose all penalty phase rebuttal witnesses, including expert witnesses, with the same requirement to disclose any and all records relied upon by the experts. So I'm assuming everyone's complied with the court order.
Judge, we did list a witness, an expert, and I believe we've drawn his name since we listed him. Does that sound right? Dr. Myers. Yeah, we have been working on trying to replace him. He had to jump off because of volume of other cases. So we're searching right now. We've been searching, so.
Okay? Is he what type of expert is he? Mental health, rebuttal?
Yes, he was a forensic psychiatrist. So
Okay. And,
that's for potential rebuttal testimonial.
okay. And then, have any of the defendants listed a mental health mitigation expert for penalty
Judge,
phase?
if I could just ask a question regarding Mr. Harmon's statement. I assume that was Dr. Myers as it relates to a particular defendant, Mr. Murphy, or?
Oh, no, it was Dr. Myers. I listed him and I believe all defendants.
Okay,
Okay. Yes.
Okay. So have the defendants identified mental health mitigation experts in their penalty phase witness list?
Judge, Jenna Finkelstein on behalf of Sean Gathright. I did list a doctor, and I indicated on there it was for mental mitigation. We are working on scheduling her deposition. I provided a couple of dates. I do not have a report yet, so I'm hoping she gets that over to me. I spoke with her yesterday. That way I can get it to the state before the deposition. As far as records, there really isn't much, so I shouldn't have anything voluminous to send over.
Is the depot scheduled?
We talked about 2 dates. I sent over 2 dates yesterday. We don't have it yet scheduled, but we were looking at March, I think I said 25th and 27th.
Okay. What about Mr. Chance?
We listed 2 doctors, we had to remove one, but the other doctor we have scheduled for Monday.
For depot?
For deposition.
Okay.
She didn't do a report, and I'll verify that. I don't believe she has any record for herself, so no budget.
Okay, that's fine. Well, at a minimum, at her deposition, she needs to be prepared to answer if she relied upon any records and to bring them with her, so they can be disclosed. Okay, what about Mr. Davion Murphy?
Yes, sir. We listed one expert. He has been disclosed. The report has been disclosed. The documents have been disclosed. There might be a potential for listing another expert because we're waiting on an order, and I advised Mr. Harmon of this. We're waiting on an order, perhaps the court may have it, for funding for a neurologist. And then funds to expend for potential brain scans. Brain scans.
Okay, and what type of doctor is the expert that you have listed?
He is a neuropsychologist.
Okay. This would be a different type of expert?
This is a neurologist. We would need a neurologist and then a neuropsychiatrist.
But you have the person lined up, correct?
Yeah, we're just waiting on the orders.
Let me take a look.
I didn't file these motions, but I was in trial, but.
Let me just take a look. There's nothing in my queue. I think I signed some orders a couple days ago
Okay.
that were,
Order on neurologist, okay. Okay, so let's, we'll do
yep, I signed both those orders on yesterday.
Yes, sir, so the neurologist and then the funding for the reading and scans.
Yeah, I'm not looking at the orders, I'm just looking
Okay.
at the title, but I signed 2 orders yesterday for your client, so I'm assuming that's what they are. So the fund's been authorized, so how quickly can you get this expert witness listed in discovery?
I would first have to get this, and my client potentially, well, first I need a script, then I have to get my client to the facility to get scanned, then I have to get those discs, then I have to send them to the other individual, and so it'll take a little bit.
Okay.
Part of the issue will be also working with the facility to get a date
Okay.
and transport.
All right, so Mr. Davion Murphy still needs to identify his second expert that he intends to call. Mr. Chance and Mr. Gathright have identified their potential mental health expert witnesses. And then what's going on with Mr. Rashad Murphy?
Judge, don't quote me, but I believe the court might have had a colloquy with Mr. Hernandez this morning, and Mr. Harmon maybe can correct me, conversations with Mr. Hernandez about deposing his expert?
Yes.
But he's listed him.
Yes, he said he had listed him. I'm not sure what type of documentation
Sure, that's fine.
followed. But yes, he's been listed.
At this point, I'm just trying to make sure all of the witnesses have been identified.
Judge, although I can't tell the court I was 1,000% listening, that's what I recall happening this morning, is that Mr. Harmon acknowledged that Mr. Hernandez had provided him the name of an expert.
Yeah, so, Judge, just to put on the record, all penalty phase counsel has been communicating, we've all been communicating by email about these experts, setting them for deposition, and it's been going very well. All of them have been in communication with me, trying to provide dates and get dates from their experts. Mr. Hernandez emailed me on the 25th of February about Dr. Collins, I believe. Is that correct? Brian, does that sound right?
Scott, I can't tell you.
Okay, so Dr. Collins, he emailed, is planning on visiting Mr. Murphy one more time, proposed deposing him in mid to late March if that works, and that does work for me, as long as I can, have time to get him deposed and get the transcripts back. So.
Okay. So let me just take a look at the calendar here. So, Mr. Harmon, for all of the experts that have been identified, the defense experts, has a deposition date been scheduled?
Not for all of them. I believe the only one I have scheduled right now is with Mr. Petridis. Is that correct, counsel?
We are scheduled for Monday, yes.
For Monday, yes. Ms. Finkelstein's already indicated she provided dates, and hopefully we'll have that set up by hopefully the end of the day. Ms. Toomey has provided dates, is that correct?
That's correct.
Yeah. So, I was out yesterday. I know they both sent emails to me, so I haven't had a chance to review them.
Okay. So you guys have until, today's Wednesday, close of business this Friday. I want you all to at least have dates agreed to, okay? For any outstanding witnesses, specifically the expert witnesses. And then as to the potential new expert for Davion Murphy, the neurologist, how much time do you need?
Judge, I'm going to have to get with the doctor and see how quickly he can go out and see him so that I can get the script, and then I
Okay.
can contact the facility. So I can email him now during this
Yeah.
afternoon and see when's the earliest he can.
And it needs to be rapido, not, because we got to start, I want this done before we start picking our jury, okay? So my preference would be on or before, at least gets identified on or before March the 20th.
Judge, back to the setting of depositions for all witnesses, including experts. I'm responsible for doing the penalty phase lay witnesses, and there are numerous ones, and I have not started to coordinate. Could I have by the end of the week?
Yeah,
Thank you.
by 5 p.m., March the 6th.
Thank you.
All depositions need to be on the books, okay? And then state, how much time do you need to get your rebuttal, penalty phase rebuttal expert identified?
I would ask for at least till the end of this week. I've been speaking with Ms. Toomey about her potential anticipated expert. I've already started looking for a rebuttal witness for that anticipated testimony, depending on if the PET scans or brain scans lead to what I'm believing it may or what they may present. So.
Okay. So are you telling me that you've got to for sure hear from Ms. Toomey regarding this neurologist before you can identify your potential penalty phase rebuttal
Well, she had
expert?
mentioned Dr. Wu, and I've dealt with Dr. Wu before. You may recall Dr. Holder from the, I want to say the Ritchie case. He has now become medically incapacitated, so I'm trying to find another radiologist, neurologist to rebut.
Okay.
But I started, she had brought that to my attention last week when we were all having discussions about where we're at in penalty phase with our preparation, and I started looking. So.
Okay. So, Ms. Toomey, see if you can make contact with your potential expert this afternoon, and then we'll discuss this again. Okay?
Yes.
Okay. All right, so let's start off with the state's motions in limine. You all were present, so state's first penalty phase motion for order in limine. Is there any objection to that being granted? Okay, for Mr. Chance? What about Mr. Gathright?
No, Your Honor.
Okay, and Mr. Davion Murphy?
No, Your Honor.
Okay, so that motion will be granted as to all defendants. Moving on to state's second penalty phase motion for order in limine, having to do with regards to any argument or evidence concerning the actual method of execution or any description of an execution or the method of execution. Any objection by Mr. Chance for this motion being granted?
No, Your Honor.
Any objection from Mr. Gathright?
No, Your Honor.
Any objection from Mr. Davion Murphy?
No, Your Honor.
Okay, this motion will be granted as to all defendants. All right, next up, state's third penalty phase motion for order in limine regarding the individual beliefs of any person, organization, or religion on the death penalty. Mr. Chance, Mr. Petratus, on behalf of Mr. Chance, any objection to this motion?
No, Your Honor.
Any objection by Mr. Gathright?
Your Honor, I don't have an objection. What I did advise Mr. Harmon, and I believe it's not stated in the motion, so it shouldn't be an issue. He said argument or evidence. Obviously, this comes up in jury selection. I just wanted to make sure it wasn't.
Yeah, no, we're just
included in
talking
that.
about penalty phase evidence.
No
Okay.
objection.
All right, and then Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. State's fourth penalty phase motion for order in limine. This has to do with any description of death, including any deaths depicted in any novel, motion picture, or television show. Mr. Petratus, on behalf of Mr. Chance, any objection to this motion?
No, Your Honor.
Mr. Gathright, any objection?
No, Your Honor.
Excuse me, on behalf of Mr. Gathright.
No, Your Honor.
And on behalf of Mr. Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. State's fifth penalty phase motion regarding comparing the facts of this case specifically to any other capital case. Any objection to me granting this motion? Mr. Petratus, on behalf of Mr. Chance.
No, Your Honor.
As to Mr. Gathright, any objection?
No, Your Honor.
And Mr. Davion Murphy, any objection?
No, Your Honor.
No, Your
Okay,
No, Your Honor. I was just making sure I didn't.
sure. This motion will be granted as to all defendants. State sixth penalty phase motion having to do with the changing the laws regarding the death penalty in the state of Florida. Any objection, Mr. Petratus, on behalf of Mr. Chance, to this motion? On behalf of Mr. Gathright, any objection?
No, Your Honor.
On behalf of Mr. Davian Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. And as to all defendants, the state filed the state's motion to compel that the defendant provide penalty phase witnesses and evidence. And this motion will be granted as to all. And again, I have a scheduling order, and we will continue to discuss this. And as always, if there's an issue, just let me know. The sooner you let me know, the quicker I can deal with it. Okay, I think that's it for the state's motions. So let me just break down. Let's see. We're going to start with Mr. Chance. Hold on 1 second. Let me get all of Mr. Chance's motions in front of me.
Yes, Your Honor.
Okay, very good. I have them. Where would you like to begin, Mr. Petratus?
The courts. I know you
Okay.
have them in order.
I just will go in the order I have them right now.
Yes, Your Honor.
Okay, very good. Okay, let's start with the motion to declare Section 921.141L, I believe, Florida statutes unconstitutional and to bar state's use of hearsay evidence in penalty phase proceedings. Right? Any?
Judge, I'm going to rely on the motion and the case law contained therein and have no further argument.
Okay. And Mr. Harmon?
Judge, we filed responses to all of Mr. Chance's motions, and we'll rely upon our written response.
Okay. All right, I will deny the motion to declare statute 921.141, I believe that's L, unconstitutional, and I will also deny the request to bar the state's use of hearsay evidence. Hearsay evidence is admissible at a penalty phase proceeding, assuming that the defense is given a chance to rebut that evidence. So that motion will be denied. All right, next up, motion for findings of fact by the jury.
Yes, Your Honor, we would, Mr. Chance, we would rely on the argument and case law contained therein and have no further argument here today.
Okay. State?
Your Honor, we filed a written response. I'll rely upon the state's response.
Okay. And just for the record, this motion would, is asking that I say that the jury's got to find additional findings of fact other than what the jury instructions require them to do in a capital case. So I will deny the motion. All right, a motion to declare 921.141 6N unconstitutional.
Judge, we would rely on the motion, argument, and case law contained therein.
Okay, and this is the criminal gang member aggravator, correct?
Correct, Your Honor.
Okay. Mr. Harmon?
Judge, we filed a written response. We would rely upon that in the argument that the aggravator is constitutional, especially in light of the heavy amount of evidence of showing a nexus between the facts and the aggravator.
Okay. That motion will be denied. All right. Motion to declare cold calculated and premeditated aggravator unconstitutional.
The same, Judge. We would rely on the motion and the case law therein.
State, you rely upon your response?
Yes, Your Honor.
Okay. I will deny that motion. Motion to declare 921.141, 2 and 3 Florida statutes unconstitutional. Mitigation must outweigh aggravation.
Same, Your Honor. We rely on the motion, the argument, and the case law contained therein.
Okay. Mr. Harmon?
Your Honor, we'll rely upon our written response.
Okay. We're going to stick with what is required currently under the law for the jury, so I'm going to deny that motion. Motion to declare Florida's death penalty unconstitutional based on violations of Article 1, Section 4 of the Florida Constitution and the First and 14th Amendments to the United States Constitution. Mr. Petratus?
No further argument, Judge. We rely on the motion, the cases and statutes contained therein.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
Okay. I will deny that motion. Motion to declare 921.141.7 Florida statute unconstitutional and for pretrial determination of admissibility of all victim impact evidence. As to the, let me see, unconstitutionality of victim impact evidence, any additional argument, Mr. Petratus?
The only thing additional I'd say is I know the court had a specific ruling as to when Mr. Hernandez was up here. I believe you said it to all defendants, so
Yeah.
other than I
So,
assume-
yes, so any victim impact evidence has got to be in written form, and the state has to provide that letter, that written form to you all at least 24 hours before any person would testify. And at this point, it's got to be an adult. And at this point, the state's not limited to the number of individuals. However, at some point, they may be. So you can always renew an objection if you feel that there are too many individuals that they intend to call for victim impact.
Yes, Your Honor. No further argument other than that, Judge.
Okay, so I will deny the motion as to the unconstitutionality of Section 921.141 subsection 7, and I will grant the motion with regards to pretrial determination of admissibility of all victim impact evidence, in that the state's got to disclose what they intend to have read to the jury, and then if there's a dispute or a challenge, I'll hear it.
Yes, Your Honor.
Okay?
Thank you.
So denied in part, granted in part. Okay. Defendant's motion to preclude imposition of capital punishment.
Judge, I'll just rely on the motion and the case law I cited in the motion.
At this point, well, any response, Mr. Harmon?
No, Your Honor, other than our written response, Your Honor.
Okay. So at this point, I read this as a wholesale motion to preclude imposition of capital punishment. So I'm going to deny the motion. However, you're not prevented in the future from, particularly assuming we get there, at a Spencer hearing, any arguments that are available to you legally.
Yes, Your Honor. Thank you.
Okay. But that motion will be denied. All right. Do you have any others?
I have one more.
Okay.
I believe objection to death qualification of the jury.
All right. I don't see that, but it may be here somewhere. And tell me what the motion is.
I should have it here, Your Honor. That's a long
Oh, wait,
one.
hold on.
If I could have.
It was 14 on the list, if that helps.
Well, it was when everything was in line, but I took it all out, so now it's good luck, okay? Good luck putting that. Okay, oh, here I've got it.
Okay.
Good luck putting that genie back in the bottle. All right, let me just take a look. Okay. State, any further response?
No, Your Honor, we filed a written response. There are multiple grounds raised in the motion other than death qualification. We addressed each in our written response.
All right, the motion will be denied.
Thank you, Your Honor. I believe that's the last one I filed.
Okay. All right, so moving on, Mr. Gathright, on behalf of Mr. Gathright. Okay. Do you have a particular preference as to order?
You can tell me.
Okay, all right. I'll just
Whatever you
go-
have there, I'll go with you.
Okay, I'll just go in the order I currently have them. Okay. So, motion for victim impact statements to be read by a neutral party. State what's your response to that.
Is this the motion of voting general procedure?
No, this would be Gathright, motion for victim impact statement to be read by a neutral party. I guess they don't want an actual,
I believe I filed a response.
yeah,
to
you
that.
did.
And we object, obviously, to that.
Right. I mean, family members can read their statements, correct? Under the law?
Yes.
Can and they do.
And Your Honor, we would just ask for the same ruling or indication from the court as you did earlier, as far as if there's any minors.
Right. So, same situation, any victim impact evidence, if there's going to be a written statement that's read, it has to be provided to defense at least 24 hours before the victim reads the statement. And at this point, it cannot be a minor unless we talk about it. And if there's any dispute, then I'll take a look at it and I will resolve the issue. So, as to the specific request that the victim impact statements be read by a neutral party, I'm going to deny that motion. Motion to declare Florida Statute 921.1418 victim impact evidence unconstitutional.
Yes, Your Honor, we'd rely on our motion.
Okay, state you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to preclude any potential death penalty proceedings based on violations of the constitutional right to a grand jury indictment.
We would rely on our motion, Your Honor, indicating aggravating circumstances or elements of a capital homicide which must be pled by the state attorney and unanimously found by a jury.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to strike proposed aggravating factor number 1 from the state's notice.
And Your Honor, I think based on a conversation we had last week, we can withdraw that motion. My understanding is the state's solely relying on the facts of this case that would be
Right.
heard in guilt phase.
A contemporaneous conviction, not anything prior.
Right.
All right, so that motion is withdrawn. Next up, motion to declare Section 921.1416C unconstitutional on its face and as applied. This is the risk of harm
Yes.
aggravator.
Great risk of harm aggravator, finding it vague and overly broad. We'd rely on the memo in our motion.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied. And motion to bar imposition of death sentence on grounds that Florida's capital sentencing procedure is unconstitutional.
Yes, Your Honor, we have indicated in that motion that the procedure is currently unconstitutional, permitting a verdict of death on a non-unanimous vote of the jury, and would rely on the memo contained in our motion.
Okay. State you rely upon your response.
Yes, Your Honor.
All right, that motion will be denied. Do you have any others?
We had, it looks like, motion to declare 921.1416I unconstitutional. Let's see, and that's for CCP.
Okay.
You see
And
that
I've
one?
been saying I, is it I or one? I don't know.
It's I.
Okay. Um,
And we'd rely on our motion.
Okay.
If you have it. Do you have it?
No, but the motion is filed as to declare the CCP aggravator unconstitutional.
Correct.
Okay, that motion will be denied.
Let me just double check. We did have a few motions in limine. I think we can agree on most of them, but
Did you
just,
cover the victim impact?
we did.
motion?
Yeah.
Both were denied.
There's a motion in limine as to general procedures, I believe.
Yes. Oh, and I'm sorry, Your Honor, there is one more we filed the motion to strike the aggravator that was withdrawn, but we do have a motion to declare 921-1416B, the prior capital or violent felony, the constitutionality of that. And we'd rely on that motion if you have it. That one was filed. Some of these were filed at different times, which may be, that one was filed early January. And state did file a response to that as well.
Okay, do you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied.
I think that was it for the constitutional and those motions. We do have a motion in limine for general procedures.
Okay, what does it state?
The first one, I believe the state didn't have any objection. Section A of that motion was reference to non-statutory mitigating circumstances and use of words such as catch-all.
Yeah, we have no objection to that.
Okay, granted.
The next one was Section B, the presence of media, family members, and uniformed officers and shackling of the defendant.
Okay,
I know this, go ahead.
No, it's okay. Your Honor, I spoke to counsel about this last week. We agree, obviously, to any kind of shackling in the presence of the jury during the guilt phase. It's my recollection from Kuzchok, and I believe Ritchie possibly, that during penalty phase, we maintained that. The defense don't sit on the building, and the shackling is outside. It's covered up to the jury.
yes.
Okay. As far as the other matters in that ground, we would defer to the court as far as the media, anything like that.
Okay. And tell me, I feel like I've seen the motion, but I can't find it right now on my desk, so.
Your Honor, essentially, we are asking that the court instruct the members of the media to not interview witnesses, family members, courtroom personnel, people involved in a place in the courthouse that could be subject to the jurors observing, seeing.
Okay.
I believe there's also a ground about use of cameras in the courtroom. If I'm just kind of looking at this from last week, there's an administrative order that deals with that.
Right, there's only one camera that's permitted in the courtroom, and it's got to be out of the way. And I do have a whole discussion with the jurors that they understand that their faces will not be shown, their identities will not be disclosed. So I guess the motion will be granted in that the media knows, and they've got to follow a certain procedure established by the courts, and I assume they will.
Perfect. The next section, we were asking C, names and addresses of potential jurors summoned to try the case and individual questionnaires. I don't believe that's Your Honor's practice, but we were seeking to do individual questionnaires for the jurors.
Okay. That will be denied. And then as far as the names and addresses, we get those the day the jury is pulled. So, and I think I told you all we're going to do 3 days of 150 back to back. So you'll get the 150 on the Wednesday, the next 150 on Thursday, the next 150 on Friday, the morning of.
Okay.
Okay? So you'll get them, but not before that.
Not now.
So I
Okay.
guess it's granted, but you'll get it the day of.
And we were also asking for individual and sequestered voir dire. My understanding is that the court does the individual or smaller groups as to hardship or media exposure.
Yeah, so individual voir dire will be done on anybody that thinks they know anything about this case. With regards to hardship, that will be done as a group for those that are claiming a hardship. And then on death penalty voir dire, that will be done again in small groups. That's not my traditional practice, but because of just the number of people that will be coming through for jury selection, I am going to break it down, the death penalty qualification questions, into smaller groups. So probably the 30 to 40 range, we'll see, whatever we think we can get through in a day. So, and I think I did mention this before, that normally I have a whole speech that I do before phase 2, which is death qualification. And I know the state has Mr. Harmon has a speech that I've seen him do before he begins. And normally I give the speech when we actually move on to phase 2. But in this case, what I'm going to do is I'm going to give my speech first thing Wednesday, Thursday, and Friday to the group of 150 as a whole, just because it is can be time consuming, and by the time I get done talking and by the time Mr. Harmon gets done talking, and then if the defendants wish to make a statement regarding penalty phase questions, it's, we're now into an hour and a half and we haven't even started talking to any of the jurors. So my plan is that Wednesday, Thursday, and Friday, the first week of picking the jury, I will give my speech to everyone there, but I will remind them that we're not going to be asking them any questions related to the death penalty in phase 1. And then if those that come back to go into phase 2, which are the death penalty questions, I will then just give them a brief reminder of what I said to them, and then I'll give Mr. Harmon a chance and the defense counsel a chance to give a brief reminder before we actually begin the questioning of the jurors.
Okay.
So if you all want to make a succinct speech regarding death penalty voir dire,
Okay.
you're welcome to do so. Okay? Perfect. You'll do it Wednesday, Thursday, Friday morning
Once
of
we
the
pare
group.
down a little bit.
Well, you do it initially to the whole group,
Okay.
and then those that make it to phase 2, like I said, we'll do just a quick reminder of the points that were made when they first came in, but we're not going to do another wholesale intro for each of those small groups because it'll take forever. Okay?
Okay.
Okay.
Let's see, next was section E, objections being made contemporaneously with the occurrence of error to avoid procedural default. No, did we discuss that, Scott? I don't remember if you had an agreement to that or not.
No, I don't believe we did.
Okay.
Actually.
So is there any objection?
Judge, I would just, so if I could ask counsel for clarification about contemporaneous objections. Objections made at the bench, objections made from counsel's table.
Just so there's not speaking objections from the
Right.
council table.
Oh, okay.
Granted.
Thank you.
I don't like speaking objections.
No, I don't think anybody does.
Some people like them, or at least some people
That's
like to
true.
make them. They
Yes.
do, but,
Or some judges, when you say, can we approach, and they say no, and then you have to do it. So.
right.
And the last one, I believe, is section F, which was miscellaneous matters. And I believe that the state is in agreement with that section.
Yeah,
Correct
Your
me if
Honor,
I'm
I
wrong.
know it's the court's, in the past, being in front of Your Honor, when the state asked for the record to reflect that a witness has identified the defendant, the record will so reflect. There's
Right.
something to that.
That's all I ever say.
Perfect.
So I guess it's granted with the understanding that that's what I will say.
Okay. And I believe that is it. We handled the state's motion to eliminate. Is that all you have?
Yes.
Okay.
Okay?
That's all on
right.
behalf of Mr. Gathright. Thank you, Your Honor.
Okay, thank you. Okay, and Mr. Davion Murphy. All right, you want to start off with defendant's motion to strike aggravating factor, section 91.1416N as unconstitutional. and that's the criminal gang member aggravator, correct?
Judge, are you talking about my motion to strike? I apologize.
Yes.
Okay, so my motion to strike the aggravating factor 921-141BN.
Oh, we're switching to a different, I was
Oh.
looking at 6N.
Okay.
But that's fine. We can start wherever you want to start.
No, I was going to start at the general procedures
Oh.
and work from there, but whatever Your Honor wants.
Okay. It really doesn't matter.
I think it's probably the easier. Not that anyone would be hard.
That's fine. So where do you want to start?
The motion in limine regarding general procedures, I
Okay.
spoke with the state. I think we're pretty much in agreement.
Yeah, the motion is very similar to Mr. Gaffrey's motion.
In that it appears the state agrees with paragraph A,
I do, the state does agree with that.
and that
Okay.
is in regarding the non-statutory mitigating circumstances. Paragraph B, if I recall, you left that up to the court's discretion, and that will be the presence of media, family members, and uniformed officers, and shackling of the defendant.
I don't think we address family members. As far as that goes, I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear anything that's provocative to the jury, such as photographs or any kind of remembrances.
Right. And the defendants are shackled, but not obviously to the jury.
Yes, Your Honor.
And so I guess the motion is that paragraph B technically is granted with the understanding that there's an administrative order that deals with the media. Family
Yes.
members can be present, they just can't wear anything that might be considered inflammatory or sending a message to the jury. And uniformed officers obviously can be present in the courtroom, you have to have security, and the defendant shall be restrained, but not so that the jury can see.
Yes, Your Honor.
So it's granted to that extent.
And then as it relates to paragraph C, names and addresses of potential jurors summoned to try the case, I heard the court in addressing this motion previously. I guess we obtain or are provided the names and the addresses, I think, the morning of.
Yep.
Okay.
So no questionnaire, and then you'll get the names the morning of. So deny the motion as to a questionnaire, grant it as to the names and addresses, and again, that will be provided the morning of jury selection.
And then D, individualized and sequestered voir dire. I also heard, Your Honor, as well. I have done it both ways. I feel as if it's more effective, at least to do the penalty phase portion of it individually as opposed to like in sections of 10 or, 15 or what have you, but.
Yeah, I'm not doing individual, no, we're not doing that, so. We're doing, as I said, small groups, anywhere 30 to 45. We're going to see what's workable with the number of attorneys we have. But
Understood.
it's not going to be done individually. So as to paragraph D, that's denied.
And then E would be very similar to what the court has previously ordered with regards to objections. Obviously, there should be no speaking objections.
Right, that's granted.
And then F has to do with miscellaneous procedures, one of those being where the state wishes to identify a defendant for the, quote, record. I would ask that that be done at the bench as opposed to the court commenting that the record has reflected that so-and-so, whatever witness has identified the defendant. If that's what the state is requesting, that be done at the bench.
I'm going to deny that request, so the state can ask it just if the record reflects, and I will indicate if the record so reflects. Okay?
there's no longer the issue with the
Okay,
expert. Okay, so then the next one, if Your Honor may, motion to declare Section 921.141B1, which is CCP, which I believe the state filed a response to, and I would just stand on my motion.
okay.
That was on CCP, counsel.
Yes.
Do you know what?
6I.
It's 6.
What I-
6I,
Maybe I
yep.
said.
Okay, that motion will be denied.
And then the next one would be motion to declare 921.1416B
Unconstitutional as written at, and as applied, and that relates to the prior violent felony aggravator. I believe the state also filed a response.
Does this defendant have an actual prior?
I looked, I thought that it was in the,
Does he, or are
In
you
the
just alleging the
notice.
contemporaneous conviction?
Judge, I can't speak to whether he does or not. I know all the defendants were relying upon contemporaneous convictions for violent felonies. I believe this is Mr. Murphy, Davion Murphy.
Yes. I think it said or. I'm almost positive.
Do you believe he does, counsel?
I believe that the notice said or.
Or, okay.
Yeah.
Um,
I believe that's the wording in the statute, so we utilize that wording. So.
Okay. Well, as to it being unconstitutional, I'll deny the motion. But obviously, before we head into a penalty phase, if the state is going to rely upon a prior violent felony conviction, you've got to make sure you've given them the defense. So
Yes, Your Honor.
you need to let them know before the start of trial, okay?
And then the next one will be motion to declare 921-1418 unconstitutional and for a pretrial determination on the admissibility of all victim impact evidence.
Okay. So as to it being unconstitutional, I'll deny the motion, but I will grant it with regards to a pretrial determination of admissibility.
Yes, Judge. And Zong, obviously, that would receive those letters
Yes.
in advance. Then
Yeah,
that should.
same ruling, at least 24 hours before anyone should offer the victim impact evidence in court before the jury. Has to be disclosed.
And then I would also adopt, I did not file, although I did tell Mr. Harmon that I was going to be adopting the motions that have been filed on behalf of the other defendants regarding the constitutionality of the new death penalty scheme applying to Mr. Murphy, not based on ex facto or anything of that nature, but based upon just general 8th and 14th Amendment rights. So I would adopt all of those motions and incorporate those
Okay.
in his argument.
Same ruling, be denied.
Okay, and then finally, we have motion to strike the aggravating factor. I think is that what you started with?
I have, defendant's motion to strike aggravating factor, Florida statute section 921.1416N, which is the criminal gang member aggravator. You relying upon your motion?
I'm relying upon my motion, yes, Judge. Yes, I am.
Okay. State, you're relying upon your response?
Yes, Your Honor.
Okay. That motion will be denied as to the unconstitutionality of that aggravator. All right, Ms. Toomey, any other penalty phase motions?
The only other thing that I might add for the record with regard to this specific aggravating factor, specifically for criminal gang members or associates, that has already been enhanced, I guess, if you will, in the indictment. So it's almost like a doubling up of that sort of kind of enhancement. So I would just make a general constitutional argument against the doubling up.
Okay. Same ruling, be denied.
I think that's it.
I believe so. The
Yes.
list I have.
Okay.
Your Honor, if I could readdress my motion to compel, so I can kind of let the court know where we're at as far as documents and records. Ms. Toomey has provided me with voluminous records, and I appreciate that. All types
Of what kind of records?
School records, I believe DCF records, other records, medical records possibly, in relation.
Social Security records.
Social Security records dealing with Mr. Davion Murphy.
Yes.
I know, Mr. Petridis, have you listed more than one expert? Is it multiple?
Yes.
I thought you had, okay. So I haven't received any records from any other penalty counsel. And it's my understanding if there is any that will be provided, I just wanted to bring that to the court's attention.
Okay.
I've reached out to my experts. I don't have anything to say, but I told them to check and if we don't have anything, obviously I'll send it to Mr. Harmon immediately.
Okay.
That jogged my memory, Your Honor. We have a small number of school records from Mr. Gathrid. I did a notice of intent to rely, but now that I think about it, I don't think I actually sent the records to the state, so I'll do that today.
Okay.
It's a very 10-page thing.
Okay.
And then I think that's it on behalf of the records.
Okay. And have you received any records from Mr. Hernandez for Rashad Murphy?
I have not, Your Honor.
Judge, I'm going to text Mr. Hernandez now, and I'm going to also make a note to speak with him after the proceedings.
Okay.
And judges, is there a deadline on those records?
Well, yes, the deadline is come and gone.
Rapido, I heard the court say Rapido.
Pursuant to my scheduling order, those dates have come and gone. But anywho, I tell you what, let's do this. We're reconvening Friday, correct?
We are, Judge.
So I want you all to just make sure you've checked to make sure you have disclosed or are disclosing any records that you're going to rely upon in penalty phase. And then let me know Friday what your status is. And then if they've not been produced, then I'll give you an absolute, like, I'm not kidding deadline. I know my scheduling order should have been an absolute, I'm not kidding deadline, but things happen, so. Okay, and Miss Toomey, I know you were busy, but have you heard back from your neurologist by any chance?
I emailed him.
Okay.
I can.
That's fine. So we're reconvening Friday, so I just need to know by Friday when he's going to be able to get his evaluation done, so that you can determine whether or not you're going to list him.
And that's exactly what I sent, but I have not read.
Okay, that's fine. That's fine. Okay. Okay. Anything else we can get done today? Any suggestions?
Judge, I did have a motion in limine to all defense attorneys to requesting that they provide us with any sort of drill rap videos that they intended to use to list them and provide them in discovery. I don't think we addressed that.
Judge, if the court will allow, I have a brief response on that.
Sure.
Somewhere.
Judge, if I may, while we're waiting.
Sure.
I did file a motion, I'm assuming that this is probably going to be heard on Friday with all the other gang stuff.
Yeah, unless it's something we get done today, relatively simply. No? Okay.
Not because of me.
No, I'm not. It's okay.
Judge, if they would prefer it be heard with the other gang motions, that's fine. I just thought that that was something, because I was just asking that it be provided in discovery and listed.
Right, that's what she's asking at this point. Not the admissibility, but just that if you've got any other drill rap videos other than what the state is intending, and have you disclosed to the defense the ones you actually intend to admit at trial?
Judge, we will. I know we've listed probably more than we intend to use, but we will specifically list the ones that we intend to use.
Okay, yeah, by the time we reconvene Friday,
Yes.
you need to specifically identify the drill rap videos that you want to show the jury. And then if there are any drill rap videos that the defendants wish to show to the jury, they need to be identified and given to the state by Friday.
And Judge, certainly, the evidence view, we on Friday are going to talk about getting together. It'll be, as the court can imagine, monstrous.
Yes.
There may be some non-testimonial issues that come out of that evidence view that may be need to be addressed by the court,
Sure.
but we can advise you of that. My only additional concern in this state's motion in limine is that it doesn't limit itself just to videos. It suggests that the defendants refrain from making any direct or indirect mention or introducing into evidence any non-disclosed evidence of the victim's prior gang activity or videos. And I would object, and I don't think it's appropriate to suggest at this stage of the game that we should not be allowed to either question or seek admission of evidence or mention or have argument to what is described as the victim's prior gang activity. Now, granted, the court hasn't ruled on any of these things
Right.
yet, and I don't want to predispose or predetermine what that may or may not be. I agree wholeheartedly that we should be providing the state any rap videos we intend. But as it relates to argument or mention or questioning, I don't think that we can blanketly, as the motion is written, at least Rashad Murphy, agree to that.
Okay, and I'm not ruling on that motion yet. The sole issue that I hear Ms. Doherty raising is she just wants to know if there are any other in the universe of drill rap videos. Are there any other drill rap videos that any of the defendants are going to attempt to introduce at trial?
Understood, Judge.
Guilt phase. So you just need to tell her by Friday if there are. So once I've ruled on the other gang evidence and whether what's coming in or isn't coming in, then once I determine that, then we can start working on the motions in limine. So we'll kick off with the motion for me to determine how much of the gang evidence is going to come in, and then we'll go from there as to the remaining motions. Okay?
Judge, there is one mention I would make. I've been working on, when I can, and because of the late nature of the deposition of state witness Robert Howard,
Sure.
I've been working on what will be a non-testimonial motion in limine as to certain portions of what I anticipate Mr. Howard's testimony will be. And I just wanted to make everybody aware. I had spoken to the state some time ago. We just did get back last week the expedited transcript of Mr. Howard's deposition, although there was a previous proffer that we've been able to rely a little bit on. So I anticipate filing that motion as well, Judge, without significant argument other than those portions that we would seek in limine.
Okay.
And Judge, I just wanted to comment on my motion in limine, because I did include gang activity. Obviously, I know that the court has not made any rulings about what will be coming in, but the state's concern obviously is bad character on part of the victim being inappropriately admissible by defense and last minute without us having the opportunity to fully vet and make any sort of arguments. So it does include not just the drill rap videos, but any gang activity that they're aware of that they intend to get into that's not been previously disclosed.
Okay. Okay. We'll start with the drill rap videos, and I don't know what that other evidence might be. I'm not really sure. So, anyway, we'll see where we are on Friday. Okay. Anything else for today?
Mr. Gathering had a couple of other motions that don't fit in any category. We can
Sure.
address those.
Just tell me what they are.
I guess one of them maybe we should have done last week, but he has a motion to sever count 6.
Yes.
I think we laid out our position in our memo, and I know the state filed a response. Our position is it's a separate transaction. I know that the state's position is there's a causal link, but we believe it's sufficiently separated that the jury should be considering count 6 separately from the other counts.
Okay, and remind me, what is count 6?
Judge, that's the tampering with physical evidence that is when Mr. Gathright goes back to his grandmother's house after the offense on the same day and wipes down the car and removes the car from Tampa and leaves it in Auburndale.
Okay. Oh, sorry.
And Judge, we did file a written response to that, again saying that that is properly joined and requesting that it not be severed, as it specifically is connected and joined in an episodic manner, which I think is the case law, which says that that is properly joined.
Okay. Any response, Mr. Wise?
Only, Your Honor, it's a separate incident that's allegedly taking place. It's happening in Polk County. It doesn't involve anyone else in the room. I recognize the state's position, but this is completely separated time, separated space. We believe it's two separate acts that should be tried separately.
Okay. I'm going to deny the motion to sever count 6. Okay. Anything else?
We had filed a motion to compel the location of all license plate readers along this path that's
right.
We have hits from, we know where license plate readers hit. I don't know, and I know the state mission discovery, and maybe we missed it. I don't think we have locations of any license plate readers that didn't hit. I know I addressed this in other, at least one other case, and I think there are some law enforcement concerns about disclosing it, but I think it's relevant if we're seeing evidence of where it hit. There could be license plate readers along these alleged paths that didn't hit. I think that's.
So you want the state to give you the universe of license plate readers along a
yes.
travel?
Between here, Orlando, Jacksonville, yeah, along these routes of travel, which I know there's more travel in this case than a lot of cases where, we're talking about just someone traveling to Tampa. But I think it is relevant Brady material.
Huh, I don't know that it's Brady. Okay, state, what's your response?
Judge, we have complied and given them all of the license plate readers where they hit. Judge, we don't know the specific path of travel, and I did specifically talk to the detective. If it is not captured on a license plate reader, it's not something that we can use in the particular case. It's a matter of timing and how the car passes. Some of these license plate readers are mobile, and so, Judge, there's no way for us to know. And there are different companies for different license plate readers. There just isn't any it's not exculpatory by any means. And without knowing the specific type of travel, when they got on, when they got off, if they took a break, there's just no way for us to be able to provide that.
But you have provided for the license plate readers that are going to come into evidence, the location of those has been disclosed.
Yes, they are disclosed by address, Judge.
Okay. All right, so I'm going to deny the motion as to any license plate readers that were not triggered during the course of travel of the defendants. Okay, I don't find that it's Brady. Okay, anything else?
Yes, Judge, there were just, I think there was a couple additional matters. You asked us with regards to that Richardson case that occurred in Jacksonville.
Right.
What was the reason that there were 2 juries, and that was a Bruton issue.
Okay.
And I believe Ms. Ismore has a copy of the actual order that lays that out, if you want us to forward a copy to you as well as defense counsel.
That's fine. I take you at your word that it was a Bruton problem. I just was curious.
And then I did want to know if the court wanted to do a formal colloquy on the record. I know that Mr. Petratus had to step out for a moment. I think it was the last time we met for motions for a small period of time. We did go ahead and order the transcripts for what happened during that time period. If Mr. Petratus wanted to take a look at that or had any sort of additional argument to make. I know that there was additional counsel that was tasked with asking questions during that time period on his behalf.
Yeah, and I just want to thank you for reminding me about that. So I think the last 2 witnesses, And I think it was Drayback and, was it Trey McCullough? Were
Yes,
those the last
those
two?
were the last two witnesses.
And I'm sure you were advised of this, Mr. Petratus, but Detective McCullough had no information related to your client at all. And then Detective Drayback, and this was done as a proffer to establish these detectives as gang experts?
Yes, Your Honor.
Okay, and I don't see Detective Drayback being declared an expert in this case, just because the gangs that he is tasked with, and I don't have my notes right in front of me, but there's a different gang or set of gangs in Jacksonville that he's focused on.
Yes, Judge, I believe we just listed him because he's not involved in a specific gang, but was the liaison and handled most of the matters as a general gang expert for Jacksonville gang activity.
Yeah, but you've got 3 other people to choose from,
Yes, Your Honor.
right?
Yes.
So at this point, it'd be cumulative anyway. So, yeah, here are my notes, actually. His gang of interest is the 21st Street gang, and he testified he doesn't have any specific familiarity with 6 Block, and he's assisted other members of the gang unit with regards to ATK and 1200, but the 21st Street gang is his specific one that he focuses in on. So Detective Drayback is not going to be testifying as a gang expert against Mr. Chance or against any of the defendants in this particular case for that reason. The state's got 3 other people to choose from, and Detective Drayback's gang is not a gang at issue in this trial. Okay? So I did indicate that the state's ordered a copy of the transcript, and if for some reason you wish to ask any further questions of either Detective Drayback or Detective Trey McCullough, then we'll set up a Zoom hearing. So,
Judge, Ms. Ismer was kind enough to provide me with a copy. I read them over. I have no further questions. Mr. Wise asked questions on my behalf, and I thank him.
Yeah.
I was present for the depositions of those witnesses in Jacksonville, so I anticipated
right.
that would be the outcome.
Yes.
So I appreciate the court.
Yeah. So just wanted to make sure. I don't, just making sure. Okay. And anything else?
No, Your Honor, I think that's all from behalf of the state.
Okay. Anything else quickly we can do today? No? Okay. All right. I will see you all Friday morning at 9 a.m. and we will get through all of the remainder of the motions. Oh, also, I did take the motion to sever under advisement. Once I've ruled on the parameters of the other gang evidence that's going to come in, then I'm going to ask each of you to, with specificity, tell me what evidence is admissible in this trial that would not be admissible if your client was being tried alone. Okay? So just be prepared to answer that question. All right? Okay, see you guys Friday morning. Do you need my notes? Yes.
Deadline of Friday as well with everything else.
Does it need to be till Friday, Judge? I expect to have it filed by end of business today.
Okay.
It may be tomorrow morning.
That's
but
fine.
It's not going to be Friday.
And the state will have anything responsive to that also found by Friday.
Okay, very good. All right, thank you.
Judge,
Is it 9?